regulatory context. You heard Julia Harrison talk about some of the issues that they're facing and how long it takes to get formal regulations through the agency. We're going to talk about also some other ways that the agency can give guidance besides formal regulations. To start with, we have to remember sort of the hierarchy of things when it comes to law. There's always the U.S. Constitution, and we can never violate the Constitution. Then comes a statute enacted by Congress, and if Congress does something unconstitutional in a statute, a court can strike it down. Underneath the statute are regulations. Agencies interpret what the Congress has done by going through formal notice and comment rulemaking under the Administrative Procedure Act and coming out with formal regulations. Those regulations have the force of law, but if they violate the statute or the Constitution, a court can strike those down. Underneath regulations are more informal policy guidance. And you heard about one of those from Julia Harrison concerning the policy manual that USCIS is developing. That's not limited to EB-5, it is agency-wide, but the EB-5 section of the policy manual is hopefully coming out shortly. Again, that is to interpret arguably ambiguous regulations or put forth procedures that are not clear from the regulations. Besides that, we have things like stakeholders meetings and informal conversations with adjudicators and trends based on analyzing how USCIS seems to be adjudicating certain kinds of petitions. All of those things go into the mix of trying to figure out how to file and get approved EB-5 petitions. So let's start historically. We know that the EB-5 statute was enacted by Congress in 1990, and then in late 1992 they added the regional center component to the EB-5 statute. And that is the last time that Congress has tinkered with the substance of EB-5 other than to extend the EB-5 regional center program. Then there were regulations. And Robert, why don't you sort of just run through quickly the initial regulations that USCIS did to implement the EB-5 statute.
Okay, so, okay. In 1991, the year immediately after the enactment in 1990, INS promulgated, published a proposed rule and a final rule for the I-526 process, the subsequent rules. And then in 1994, they did that for the I-829 rules. And in 1993 and 94, they made the regional center rules with no reference, and the 829 rules had no reference to regional centers. And then in 2009, they added the termination provision to the regional center rules. And then, I love this one, in 2002 there was a law amended about a special thing that Stephen got done for some people who got screwed in the kind of changing of approaches in the late 90s with those precedent decisions. The law was enacted, what I call the fix-it law, in 2002, and it said that the agencies should put out the regulations in like 4 months, 90 days. So that was 2002. The proposed regulations were promulgated in 2011, 9 years later. And then they've never been finalized. Right?
That shows you how slow the process is.
Now, how can be,
yes.
The 91 regulations were proposed and finalized in 4 months, total.
Now, Lincoln, in addition to formal regulations, INS, had policy memos on the EB-5 context. Why don't you just sort of briefly summarize those so people know what existed back then?
Well, I appreciate your hierarchy that we started with at the beginning. That's very helpful, and Robert has touched on how difficult it can be and how slow it can be to promulgate real regulations. So in the back end of that, we have these memos, and back in the 90s, there was something we called in practice, a few of us practiced way back then, but in September 1993, there was what we call the Virtue Memo. And this was in response, actually, to a letter from Senators Kennedy and Simpson, who were the primary architects of EB-5. and they asked a bunch of questions. So the general counsel at that time, Paul Virtue, wrote a memo to the commissioner of examinations and said basically, here's our opinion, a redemption agreement is okay. As long as the price that is agreed upon is greater than fair market value. And now we know, so that's what people operated under in 1993 and thereafter for probably 4 or 5 years. And we know then that in 1998 that was swept aside by the case of Izumi. And I think John's going to talk about that in a minute. The other thing that they mentioned in this general counsel memo is a third-party guarantee is okay as well. In other words, someone who promises to pay back the investor, this would be okay, and you have a guarantee of that promise to repay, so long as it's not tantamount to being government debt. So they asked the question of whether a bond backing up a guarantee would be okay. And the legacy INS, the general counsel said, no, it's not. This looks like it's insufficient risk on this at-risk issue. That's never really been challenged ever again. But I thought something very, very important that came out of the memo is, we don't do pre-approvals of cases. We have to adjudicate petitions based on what exists at the time of filing. The agency does not want to get a pre-approval since it must be a non-binding approval in the first place. And it's very interesting to compare that language with what we have today, and that is we have a deference policy. Some people would say, really, it's the same thing. They don't get pre-approvals. It's because they're going to review it anyways. And we know the exceptions to deference, material change would be one of them. So the way I read that is, we saw this back in 1993. It's really the same outcome, different language. And from time to time, I'll go back to these memos and read them because I find that things that are addressed in some of these memos, they never get finally resolved.